Okay, if we can have everyone leave in an orderly fashion and quietly, we'd appreciate that. Thank you all for being here and making the trip to Sacramento and to the Capitol to voice your opinion. Sergeants, if we could call some of the authors so we can proceed. Thank you. Okay. Thank you, Senator Hill, for joining us and for wading through the crowd in the hall.
Thank you very much, Mr. Chair.
We're going to go ahead and proceed. Mr. Hill has several items before us, but let's go ahead and start with, we'll start in bill order. Will that be appropriate, Senator?
Absolutely. And the first one would be?
File item number 6, SB 1039.
That's very good. Thank you, Mr. Chair and members. Appreciate the consideration today. SB 1039 is an omnibus bill that includes changes to the number of boards under the Department of Consumer Affairs and includes fee increases for several boards, including the Podiatry Board, Optometry Board, the Board of Registered Nursing, the Pharmacy Board, the Contractor State License Board, and the Dental Hygienist Board Committee. It will also eliminate a bureau under the department which registers telephone medical advice services. It was found that the services provided by this bureau are no longer necessary. Some of the more substantive changes to boards include clarifying that the Podiatric Board operates independently of the Medical Board, requiring the Board of Registered Nursing to provide better oversight of continuing education providers, providing that a veterinarian from another state or country does not have to be licensed in California to provide assistance to a California licensed veterinarian if they hold a current valid license in good standing. Clarifying the requirements for inspections and requirements made by pest control operators and their companies regulated by the Structural Pest Control Board. I would like at this time to accept the suggested amendments to strike the language which would remove the Board of Podiatric Medicine from the jurisdiction of the Medical Board. We will deal with this issue during our next sunset review of the Medical Board next year. And also the fee increase for this board will be removed in Assembly Appropriations Committee and be dealt with next year once it is determined what the new structure for the board will be and the impact on their budget. I respectfully ask for an aye vote, members.
All right. Thank you, Senator, for accepting the amendments outlined in the analysis. Let's move to testimony and support.
Laura Zuniga with the Contractor State License Board in support.
Thank you.
Thanks, Laura.
Additional testimony and support.
Mike.
Okay, one moment. Let's have that microphone turned on. If you can restate it, thank you.
Susan Saylor, Structural Pest Control Board, in support of bill.
Thank you.
Joanne Stacy with the Board of Optometry in support.
Thank you.
Jody Hicks with the Pest Control Operators of California in support.
Thank you.
Ann Sodergren with the California State Board of Pharmacy in support.
Thank you.
Christina DeCaro with the California Veterinary Medical Association in support.
Thank you. This time, let me ask if there is any additional testimony in support. Hearing and seeing none, let me move to testimony in opposition. Hearing and seeing none, let me turn it back to members on the dais for questions.
Mine's just, Mr. Chairman.
Ms. Baker, please.
Just a quick point of clarification. So you're removing the BPM provisions. Is that correct? The podiatric medicine?
Yeah, we're removing that at this time so we can have further discussions related to it.
So he's accepting the amendments outlined in the analysis.
That's the only one. Thank you.
Thank you. Senator, would you like to close?
Respectfully ask for an aye vote, members. Thank you.
All right. Thank you, members. This is file item number 6, SB 1039 by Senator Hill. This is due pass as amended to appropriations. The chair is recommending an aye. Madam Secretary, call the... Oh, I need a motion. All right, moved by Mr. Gatto, seconded by Mr. Wood. Madam Secretary, call the roll.
Salas.
Aye.
Salas, aye. Bro. Bro, no. Baker. Baker, aye. Bloom. Campos. Chavez. Chavez, no. Daly. Daly, no. Dodd. Dodd, aye. Eggman. Gatto. Gatto, aye. Gomez. Holden. Jones. Mullen. Ting. Wood. Wood, aye.
Mr. Ting, would you like to vote on SB 1039? All right. Senator Hill, that measures on call 5-3. Let's go ahead and move to your next item. That is file item number 7, SB 1046.
Thank you, Mr. Chair. In California, each year, about 1,000 people die from drunk drivers and more than 20,000 are injured. To combat this epidemic, the legislature implemented a 4-county pilot program in 2010 requiring ignition interlock devices for all DUI offenders in the counties of LA, Sacramento, Alameda, and Tulare. Over the last 5 years, thank you, Mr. Chair. Thank you. And we've had quite a reduction in the drunk driving episodes in those counties. This bill is supported by the LA Times, nurses, doctors, insurers, law enforcement, safety advocates, and MAD. I respectfully ask for an aye vote, members. Thank you.
Thank you. And that's been moved by Ms. Baker and seconded by Mr. Bro. Let's move to testimony and support.
Thank you.
Thank you, Chairman. Thank you, Chairman, for hearing us today, and I thank you for allowing me to testify. My name is Mary. I'm from Livermore. I'm a nurse at John Muir. My son, Matt, a midshipman at the United States Naval Academy, was killed by a drunk driver on a suspended license. I appreciate your aye vote on this issue today.
Thank you for your testimony. Additional witnesses in support?
Good morning, and thank you, Chairman. My name is Judy Etter. I am the victim advocate for Mothers Against Drunk Driving in Sacramento. I've been with Matt for 26 years after the death of my daughter in March of 1990. On behalf of my daughter and hundreds of victims that have been killed and those that have survived DUI crashes, and in support of the thousands that we will save, I ask that all of you pass this bill. Thank you.
Thank you. Additional witnesses in support?
Mr. Chair, members, Chris McKaylee on behalf of the California Ambulance Association, in strong support.
Mr. Chairman, members of the committee, Michael Gunning, Personal Insurance Federation of California, here in support as well.
Mr. Chair, members, Tim Chang with the Auto Club of Southern California, in support.
Mr. Chair, members, Christopher Extreme on behalf of Los Angeles City Attorney Mike Fuhrer and the Tulare County Board of Supervisors, in support.
Stuart Thomas on behalf of the California Medical Association, in support.
Michael Skippa on behalf of Alcohol Justice and the California Alcohol Policy Alliance, in strong support.
Jim Gross on behalf of the County of San Diego, in support.
Thank you. Any other additional witnesses in support? Witnesses in opposition? Seeing none, bring it back to the... Oh, sorry.
That's okay. Thank you, Mr. Chair and members. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice. We are regrettably in opposition to the bill. A couple of things. We understand the imperative and the objective of trying to prevent DUI tragedies. We're in full agreement with that. There are a number of problems with the way this bill is drafted that go far beyond the issue. And I talked about some of this yesterday because it was in committee yesterday. One is that there is a less than a 50% compliance rate currently in the 4-county pilot. Nothing in this bill addresses that. So to pass a law and expand it statewide when you have empirical evidence that there's less than 50% compliance, we think is problematic. You need to look at the study that was just released about a week ago and find out why is there a lack of compliance. This lack of compliance means that there are more folks on the road now without licenses, potentially without with warrants that are going to end up in our courts and potentially in our jails because we can't figure out how to ensure compliance. And DMV has stated that that's problematic. As far as some of the oversight, you have to keep in mind that we are creating our own problems. While this requires a judge to impose an IID, current law says that it's up to the judge to decide, which we think is a better policy. Someone in this situation also has to go through the DMV process. This bill fails to coordinate the administrative process and the court process. So we believe part of why you have less than 50% compliance rate, it's an F by any stretch of the imagination, is because it fails to coordinate the two processes. So someone may try to comply with the DMV process, and they end up not complying with the court process and with this pilot because the dates are different. The DMV suspends immediately or after 10 days. If you don't request a hearing for DMV, your license is suspended after 30 days. It does not take into consideration this bill. So we are essentially setting folks up for failure. They'll end up not having a license. Who knows if they're driving after drinking or not, because they'll be out of compliance. There's just no way to comply with both the way this bill is drafted. It's extremely problematic. And I say this not because it's a handful of people. It's more than 50% of drivers thus far that have failed to comply. We've got to figure this out and get it right. We can't make this statewide and say, well, somehow it's going to work. And at least we're helping some folks. It'd be nice, but I know you guys are better than that. I've seen your work. I see it every week. The last thing is that nothing in here treats alcohol abuse and alcoholism as a condition that needs treatment. We have laws on the books that deal with individuals who have drug problems. We treat that as a health issue that needs to be addressed. 50% of DUI offenders in California are Latino. 50%. There's nothing in this bill to address ensuring that there are more programs available, more alcohol programs, more treatment, somehow, some way, so that we don't have DUIs in the first place. Instead, we're working on the back end. Let me just close by saying only 5% of DUI offenders will reoffend within the first year. 5%, which is about the same rate as what judges were, the rate that judges were requiring ignition interlock devices. The better way to go is to keep judicial discretion, or at least have a threshold that if it's a high BAC, there's demonstration that someone has an alcohol problem, then require it. Here we're imposing the same mandate on someone who had a half a glass of wine too much at a reception on someone who's an alcoholic. That makes no sense as far as policy making. We want to stop DUIs, but we got to get the policy right, or we're going to have other problems. So fix the DMV coordination, focus on high BACs and other indicators of recidivism, and also more money into treatment so that we don't have DUIs in the first place. The evidence is clear who is drinking and driving, and we're doing nothing about it. Thank you.
Thank you for your testimony. Additional witnesses in opposition? Seeing none, I'll bring it to members of the committee. Any questions or comments? Ms. Baker?
Just one. Senator Hill, have you seen any statistics on the pilot program? And in particular, how many people it has stopped from being able to operate their vehicle while they're impaired?
Well, and thank you, Assemblymember Baker, for the question. What we've seen in some of the results so far, that the first offenders, those with IIDs, are 74% more effective than license suspension in preventing repeat offenses. 74% repeat offenses. And the opposition claimed that there's a 50% compliance rate. Well, the compliance rate before the legislation in the pilot program, 2% compliance. So 50% is not a bad increase for starting. And I think that the opposition raised a few points between the conversation and the communication between the DMV and the courts and how that can be better. And we'll work with the opposition on trying to refine that to make sure that the bill will work, and when this does pass and when the governor signs it, hopefully that we can see some legislation. But the interesting point about, you can throw everything into the pot. We're talking about those who have serious alcohol problems, and we know that they do. This is not a bill to deal with that or to treat that. We need the resources to put into this system so that we can deal with those people who are addicted. This is not the bill. This is the bill that's looking at trying to make sure that those people who have that problem can protect their families and your families when they get behind the wheel of a car. That's what this bill will do. And the fact that 50% of the people that the DUIs are Latinos, if we also extrapolate that and say that they have maybe an economic hardship in their life somewhere, this bill providing a scaled fee schedule so that those who do have an economic problem from 100% to 400% of the federal poverty level will pay from 10 to 50% of the cost of this entire process, as well as the court in this legislation will be allowed the judge to reduce the fine, the total fine for a DUI by $500.
And if I just may, I've heard a figure of $1 million.
Yes, and I'd be happy to do that. This is the Mothers Against Drunk Driving conducted, and thank you, Assemblymember Baker, for the question. The Mothers Against Drunk Driving, over the 4 pilot counties over the last 5 years, took the data that was collected by the different companies that operate those ignition interlock devices, and they found that with those devices, it prevented starts of vehicles over 1 million times of people who had been drinking, had alcohol in their system before when they were trying to get behind the wheel of that vehicle. 1 million times we were stopped. Just think of the lives that were saved just because of that. This needs to be statewide. I respectfully ask for an aye vote, members. Thank you.
Thank you. Mr. Gatto.
Yes.
Just real quick, I want to, I think we should not go forward without commending you for your work on this. You've worked on this for at least 6 years. I don't think any other member has worked so hard on this issue. You have moved editorial pages and you've moved a groundswell of support. And I just think we should thank you for that because I know this has been a long time coming. So
thank you very much, Assemblymember Gatto.
Mr. Mullen.
Thank you, Mr. Vice Chair. I just want to echo my colleague from Southern California's comments about your determination to bring this issue to light and to keep pushing as you so effectively do on these things. So if it hasn't been moved, I move the bill.
Thank you. Additional comments or questions from the committee? Seeing none, Senator Hill, would you like to close?
Respectfully ask for an aye vote, members. Thank you so much.
The bill has been moved by Ms. Baker, second by the Vice Chair. Clerk, call the roll, please.
Motions do pass to appropriations. Salas. Bro.
Aye.
Bro, aye. Baker. Aye. Baker, aye. Bloom. Campos. Chavez. Aye. Chavez, aye. Daly. Aye. Daly, aye. Dodd. Eggman. Gatto. Gatto, aye. Gomez. Holden. Jones. Mullen. Aye. Mullen, aye. Ting. Aye. Ting, aye. Wood. Aye. Wood, aye.
Thank you, Jim.
8-0, measures on call.
The measures on call, 8-0.
Thank you very much, Mr. Chair. Really appreciate that very much. Thank you, members. Thank you, Mary.
Senator Hill would like to move to file item number 9, SB 1192.
I'd be happy to. Thank you, Mr. Chair and members. SB 1192 is the sunset bill for the Bureau of Private Post-Secondary Education. The bill is necessary to make changes to the Private Post-Secondary Education Act in order to ensure continued oversight of private post-secondary institutions that supports quality, innovative programs which are approved in a timely manner, while also making sure a robust government structure prevents predatory practices and promotes student success. This bill represents an important step to enhance the Bureau's efforts, allowing good schools to thrive in a fair regulatory environment, while at the same time boosting meaningful opportunities for students. I'm continuing to work with stakeholders on an equitable fee structure and hope that in the coming weeks we are able to come to a resolution to make necessary changes, allowing the Bureau to have the resources it needs to effectively operate without burdening small schools. I'm also reviewing the final draft of the Coding the Future recommendations for regulatory oversight in high technology education field, which was produced by the Bureau's task force. Many of the task force recommendations can be handled administratively in terms of Bureau processes, but if there are statutory changes that need to be made, I'm open to including those in this bill. Specifically, both the task force report and the background paper that led to the changes currently in SB 1192 referenced a need for streamlining data for salaries and job placement. My staff and I are working on this issue and willing to make necessary amendments if those are needed. I know there are still concerns with the structure proposed for how out-of-state schools will pay into the Student Tuition Recovery Fund. I'm reviewing the language and plan to take amendments to ensure that we are not establishing a quasi-regulatory scheme, but just getting the information necessary for these schools to register with the Bureau. Members, as you know, the Sunset Review process is comprehensive, and a bill like this, with so many stakeholders, so many impacted Californians, will continue to take shape in the coming weeks. We must continue to ensure that Californians working to better their lives through education and skills-based training have some confidence in the quality of education and training they receive. It is also important for us to find ways to increase accountability for California students, as well as for the significant amount of public and private resources spent on educational training and endeavors. I respectfully ask for an aye vote, members.
Thank you, Senator. Witnesses in support?
Thank you, Mr. Chair and members. Rene Bayardo, SEIU, California, in support. We'd like to thank the Senator for just not reauthorizing the Bureau, but actually looking to improve it. In particular, we really love the ideas of having the enforcement monitor and creating the office that's dedicated to helping students, and we strongly support.
Thank you. Additional witnesses in support?
Yes, Robbie Sumner on behalf of Attorney General Kamala Harris, in support particularly provisions that would help Corinthian students.
Thank you. Additional witnesses in support? Witnesses in opposition?
Mr. Chair, members of the committee, Scott Governor on behalf of the University of Phoenix. We have an opposed unless amended position on the bill. We do want the bill to pass. We think it's largely there, but there are some significant outstanding issues which we had hoped the committee would address today. Senator Hill mentioned the STRIF provisions. We've worked positively with staff. We think we've come up with language which accomplishes the goal of providing STRIF to out-of-state students in a less cumbersome manner that doesn't require new regulations. Again, I think there's been positive feedback on that. The other issues, though, to bring to your attention, and we hope these are drafting issues, as the bill is written today, institutions would be required to report to the Bureau any regulatory action, oversight, judgment, etc., by any government entity anywhere in the world. To put that in perspective, a workers' compensation audit in Florida, a human resources issue in London, et cetera, even a fire marshal citation for too many outlets in the socket would be required to be reported to the Bureau. Failure to do so could result in a sanction against the institution. We don't think this is anyone's intent, but that's what the bill does. We suggested that they instead look at the federal composite score, which is a very clear 1 through 3 number to show how institutions' financial health is. We think that's a more logical approach. The other issue is something actually the Bureau asked for, albeit not in this manner. They, for some reason, could not use information obtained in routine compliance inspections in investigations. We don't know why that's the case, but the language as drafted says that a compliance inspection in and of itself, absent an investigation, can result in revocation of one's ability to operate. We don't think that's anyone's intent. We welcome the use of those compliance inspection reports in the investigations. Again, we don't know why they can't do it. But with these changes, we'd be happy to, support the bill. We think it should go forward to protect students. So thank you.
Thank you. Additional witnesses in opposition?
Mr. Chairman, Matt Back representing CAPS, California Association of Private Post-Secondary Schools. We cover about 200 schools throughout California, many of them in all of your districts. We, like Mr. Governor, are in opposed unless amended position. We obviously support the extension of the Bureau. We think there needs to be a fair and strong Bureau to help students, but also schools. But unfortunately, these provisions just go too far. I'll just add on to Mr. Governor's comments that we also agree that the disclosures that we would have to require are extremely burdensome and unnecessary. Also, allowing the investigations, only the inspections, not an investigation, to warrant a fine or to even close a school just goes too far, and those need to be addressed. Also, we've been talking about fees, and we're still hoping to get resolution on that, but it is important to note that many schools that are smaller with fewer students are paying more in fees than those with more students and more revenue. So we do need to address that at some point in this bill or another one. And then there are two other provisions. One adds an enforcement monitor. The Bureau already has 40-plus staff that are in charge of enforcement. This would only add additional cost, additional burden, and by the way, this enforcement monitor would have no oversight over the staff. So it's kind of like internal affairs office within the Bureau. It's only going to complicate things. It's only going to make things more expensive. And then also there's an Office of Student Assistance. This is very similar to AB 573 from last year that was vetoed. Putting this provision in the bill jeopardizes the bill's outcome. The governor vetoed 573 for a reason. Putting this in this bill could jeopardize the extension of the Bureau. We're troubled by that. So we'd like to see those provisions removed. So we look forward to working with the senator, and hopefully we can find resolution so we can extend the Bureau.
Thank you. Additional witnesses in opposition?
This on? There we go. Hi, Kathy Van Austen, MBM Strategy Group, on behalf of Bridgepoint Education. We actually don't have an opposed position on the bill at this snapshot in time. We want to see the bill move forward. One of the main issues that we have been talking with Senator about in the past is the reporting issues, how we report data, what information is collected and reported on the student fact sheets, and we have had some challenges with the BPPE in terms of what data, how we would interpret some data that is collected. The client was told during a site visit that if they send out surveys to collect employment data, that if those surveys aren't returned, those that are not returned have to be counted as unemployed. And that comes to about 75 to 80%. Anybody who sends out surveys to your districts to get opinions, you understand, a 5% return is pretty good. So we understand that there is a commitment that the BPPE is working on gathering data. We think that it is critically important, and we appreciate the senator's efforts to wait to see that information gathered, see what needs to be done, and we want to continue to work with him on that process. But it's really important that we get that right, so that whatever information we are required to report to students and to the state, that it's accurate, that it really reflects the true snapshot of what's happening, and frankly, for the students and prospective students, it's easy for them to understand and make some important decisions. So at that point, we would like to see the bill move forward.
Okay. Additional testimony in opposition? Hearing and seeing none, let me turn it to members on the dais for questions. Mr. Gatto, please.
So one thing big picture, one thing small picture. Big picture, I appreciate your work in this, and I understand that there are some bad actors in the world of private post-secondary education, but generally speaking, I think, we're painting a broad brush, in this area. I know there's a lot of schools that do a lot of good. They educate a lot of people who would not otherwise be accessing higher education. And I also think that there's a very fine difference between the schools that are technically operating as nonprofits, some of the smaller liberal arts colleges, but they're paying their president $2 million a year, and they're subsisting off the same sources of funding, education funding, and borrowing that a lot of the so-called for-profits are. Small picture. I know you were asked to take a few amendments in higher education, and I know that how difficult that can be when you're sometimes the amendments buy you some opposition that you didn't have previously. But I would like you to resolve some of these issues, particularly the ones that were raised by the witnesses. I don't think it's your intent to have these gotcha violations subject somebody to losing a license, and I'd really like to see that happen before the bill moves forward, but I realize deadlines are what they are.
And if I may, Mr. Chair, you're absolutely correct, Mr. Gatto. We've been working on some of these issues. Some of them have changed, but we, in terms of not from their perspective, but because of higher ed, it's my commitment to make sure that we can resolve the issues that have been raised. We can, I think, get close enough We don't want to play gotcha. That's not the goal, but we do want to protect those students that are in some of the for-profit institutions and make sure that they are protected and protected, and that's why an enforcement monitor we think is important. It proved to be an effective tool, and it can, I believe, make a difference in the long run. The Office of Student Assistance, it's my understanding that the administration had concerns about local assistance grant provisions in AB 573, not the creation of an Office of Student Assistance, which was not in 573. We're trying to work with the administration and everyone, and I think we will get to a good place on this. And you have my commitment on that, Mr. Gatto.
Thank you. Let's go ahead and move to Ms. Baker.
Thank you, Mr. Chairman, and thank you, Senator. I saw this in higher ed, and I held off because I wanted to be part of this discussion here. And the provision of the bill that I continue to be concerned about is the possibility that dollars go to pay lawyers to do what they would otherwise do pro bono. There is to help Corinthian college students and other students with loan forgiveness and availing themselves of the programs we already have set up. And I've seen testimony, witness after testimony, saying that I really was helped once I knew the program was out there. And I just look at page 36 and 37 of the bill, and 38, the provisions where we're trying to set up the grant program that you've identified. Right. And I don't see enough protections for making sure that we're not paying lawyers to do something that there's a whole world of law firms out there doing. And the way it works is this: there's that I've seen, and I researched this to make sure this was the case. Particularly the major law firms, but also mid-sized ones, have pro bono either coordinators or pro bono programs. These are exactly the types of cases that they are trying to connect their particularly more junior attorneys, but attorneys across the board with. They do that not necessarily through a student walking in the door of the law firm, but they go to a legal aid society that already has a pre-established referral relationship with that firm. They're there. And I'd rather see the dollars that would go into telling students about the support program that we've already set up for them than paying lawyers, and as a lawyer, this is coming from the heart, to do something that they would otherwise do for free. So that's where I'm at on this, is not seeing enough protections to ensure we're not doing that. Can you respond if you're open to working on that?
I appreciate that, because as you know, those amendments were taken at the request of the chair and higher education, and what we're trying to work with the administration, just as we're trying to work with the opposition at this point, even though they're not totally opposed, but we have a good relationship to ensure that the students and organizations get the help that they needed and that they're supported in that, and that we can make sure that that we're not paying those lawyers when we don't have to. So that's still part of this conversation. We just got out of higher ed, as you know, a week ago, and we're continuing to get there. I think we will, because I think that's all of our goal is to be in the same place. And you have my commitment to work on that and to do it.
Thank you. And I will be a no today in hopes that it'll be different on the floor, and that we will not be paying lawyers to do something they do for free. And I look forward to getting to that point. Thank you.
Thank you very much.
And thank you for working with the opposition on addressing some of these concerns that Ms. Baker raised, and I know that were brought up in higher education as well. Mr. Breaux.
Thank you, Mr. Chair. Just a statement, Senator Hill, I came in as a no, but your willingness to work with the opposition as it goes to appropriations, I appreciate that. So I'll be laying off today, and hopefully you guys can come to a resolution and we see it on the floor again.
Thank you very much, Mr. Vice Chair.
Thank you. Let me ask if there's any additional questions for members on the dais. Hearing and seeing none. Senator, would you like
yes or no vote, members? Thank you.
All right. Thank you. This is Senate Bill 1192, file item number 9. It does have a due pass to appropriations. The chair is recommending an aye. Madam Secretary, call the roll. I need a motion on this bill. Moved by Mr. Wood, seconded by Mr. Ting, I believe it was. Please call the roll.
Salas.
Salas, aye.
Salas, aye. Breaux. Breaux not voting. Baker. Baker, no. Bloom. Campos. Chavez. Chavez, aye. Daly. Daly not voting. Dodd. Eggman. Gatto. Gatto, no. Gomez. Holden. Jones. Jones, aye. Mullen. Mullen, aye. Ting. Ting, aye. Wood. Wood, aye.
Thank you, Jim.